My Lord, is at page 524. The authority starts at page 512, my Lord. But the actual holding is at page 524. We have highlighted, my Lord, the relevant part, which is the effect of what I am saying. In summary, my Lord, their lordships are saying the law is concerned with the winning candidate. There is no logic in pursuing the losing candidate. The law is not concerned with that. So it is irrelevant when we are arguing this ground that the petitioner may have, as I saw the counsel for the first respondent try to bring out at some part of the cross-examination. Now, my Lord, in paragraph 7.3, that's at page 4 of our petition, the petitioner pleaded a number or several elements of non-compliance with the law. This is in the petition at page 4 of that petition. Several elements of non-compliance were pleaded there. I may not repeat them, my Lord, because they are already in the petition. In summary, maybe, or it may suffice for me to say that the complaint was about the holding of the election in an environment that's not free and fair, the non-counting of votes cast at these polling stations, the 14, my Lord, the non-transmission of results, the non-filling of the DR forms, the non-tallying of these results, non-delivery of the tamper-proof envelopes, and final declaration of a winning candidate without receiving all envelopes from the constituency, as is the command of the law. That was the substance, my Lord, of the elements of non-compliance with the provisions of the law. My Lord, in the petition, we specified the provisions of the law which were breached. What did the respondents do in their answer? First, my Lord, of course, my Lord, I could also probably mention that the petitioner gave evidence in support of those claims together with her agents. Now, in answer to the petition, let me begin with the first respondent. What does he say? In paragraph 4 of the answer to the petition, he says, yes, there was 0-0 return from those polling stations. My Lord, that concession in paragraph 4 of the answer to the petition is repeated in paragraph 6 of the affidavit in support of the answer to the petition. When he was here for cross-examination, my Lord, he told us that he had polling agents at all the 197 polling stations, and that none of them had come back to tell him that elections did not take place in these 14 polling stations. Pressed further in cross-examination, my Lord, he admitted, 1, that there was non-counting of votes. He admitted, 2, that the other forms were not filled. He admitted from the look of the tally sheet that the results were not there. All of those elements of non-compliance were admitted while the first respondent was on the stand. Now, for the second respondent, paragraphs 10 and 11 of the answer to the petition, paragraphs 10 and 11 of the answer to the petition, and paragraphs 9 and 10 of the second respondent's answer to the petition admit a greater majority of those elements of non-compliance. Admit a greater majority of those elements of non-compliance. My Lord, will retreat and read those paragraphs. You will see what I'm saying. Further, my Lord, the second respondent filed 5 other affidavits. When you gave them leave to do so, they filed 5 other affidavits of Ahawe Fiona, Peace Shogabirwe Mugabe, Kamsime Ruhemba, Tamale Simon Peter, and Kakaire Gabastas. All those affidavits were filed on the 5th of May by your leave. Now, my Lord, the silver lining that cuts across all of these 5 affidavits, which are the evidence of the second respondent, is that 1, there was non-counting of the votes at these polling stations. 2, that as a result of violence, this counting was not completed, and therefore that no DRR forms were filled at these polling stations. This was the evidence of the second respondent. And from that body of evidence, my Lord, starting from the petitioner, the concessions of the first respondent, the concessions of the second respondent, it is our submission that all elements of non-compliance that were pleaded by the petitioner were proved or have been proved. Why do I say, my Lord, that all these things we pleaded were non-compliance? I refer you briefly, my Lord, some of the decisions that have held that each one of those things that we pleaded is non-compliance. Maybe perhaps, my Lord, to tell you that non-compliance simply means that there's provision of the law which has not been complied with, as simple as that. If the law tells you count votes, you don't count them, that's non-compliance. Fill DRR forms, you don't fill them, non-compliance. Take all envelopes before you declare, you don't do so, non-compliance. That's simply what it means. And in the petition, we specified all of those sections that the second respondent did not comply with. They told him to do something else, he did something else. Now, my Lord, I could refer you some of the decisions in our bundle of authorities that have held that all of these various things that we pleaded and which we have stated have been proved are elements and amount non-compliance with the law. The first one, my Lord, is at page 543. 543 of our bundle of authorities. This is the case of Apollo Kantinti versus Tenda Sebalu. The actual holding, your Lordship, is at page 566. It's a very small line down there. Your Lordship is telling you that if you don't tally, that is non-compliance. Yes, 566, that's where the small holding is at the end of the page. We have highlighted it. The second authority, my Lord, is Joy Kafura Kabatsi versus Anifa Kawoya, Supreme Court. That one is on failure to prepare or fill DRR forms. The actual holding is at page 631 to 632. 631 to 632. 631 to 632 is where the actual holding is. There, in very few words, my Lord, their Lordships, the Supreme Court said DRR forms are mandatory. They are not a matter of form. They are a constitutional command by virtue of Article 86, 68 rather, 68, 2 and 4 of the Constitution. So they held their Lordships, the Supreme Court, in that matter.